Hello everybody, welcome back to the English Law channel. So I'm going to carry on with freehold covenants, looking about passing them on, passing the benefit in equity. So the equitable rules about passing the benefit are really important because there are lots of situations where the common law rules don't apply, especially if the claimant relies on their land as part of a development scheme, and crucially where the servient tenement has been assigned and the enforcement is contingent on the equitable doctrine of restrictive covenants. In those circumstances, they normally argue, as per a case called Gray, about the burden running in equity and saying the benefit will also do so. So usually it's immaterial what the equitable rules for running the benefit are. Usually it's immaterial because the equitable rules about the running benefit are more adaptable and broader than for the common law rules. But equitable rules are not always discretionary, and they might still be important in a situation if there's lots of delay, a long delay. It's called laches, equitable laches, spelled L-A-C-H-E-S, or malafides. The court might say it's going to disapply equitable rules for the running of the benefit, despite the common law rules for the benefit passing. Similarly, the equitable rules for the burden are similar, so they both might be satisfied. In the last few years, courts have been more willing to stretch the rules, which in the first formulation was seen as too restrictive and too technically involved. So the covenant must touch and concern the land of the covenantee, and the claimant must also show they've acquired a benefit of the covenant in one of the three ways set out by equity, and these are assignment, annexation, or scheme of development. So I'll go through them one by one. So number one, express assignment. So the benefit of the covenant can be expressly assigned to the covenantee's successor in title. This way of transmitting the benefit is important because of Section 78 of the LPA 1925 has been ruled out. But bear in mind the following: the covenant has to be taken to protect an ascertainable land of the covenantee, and the assignment must happen at the same time as the transfer of the dominant tenement. And there ought to be something in the conveyance identifying the land that's benefited. There's a case about that, Newton Abbot Cooperative Society Limited against Williamson and Treadgold Limited, 1952. And there it was very hard to figure out what the dominant tenement was. However, the decision in that case would have been different. Would it have been different? It's debatable if the nearest ironmonger's shop had been a mile from the servient land. You also need to consider whether the assignment does not operate to annex the benefit of the covenant to the dominant tenement. So there could be several assignments, one after the other, from one owner to the next on the same terms, and that's needed as per Ray, Pinewood Estate, Farnborough, 1958. Equity permits the benefit to be assigned with any part of the benefited land. You don't have to sell the whole estate. So a covenant made with intending the benefit of the whole of the dominant land can be assigned on selling just a small segment of that land, as per Stilwell and Blackman, 1968. So number two, annexation. As I said here and before, it's possible for covenanting parties to expressly annex the benefit of the covenant to the dominant tenement. So the covenant must show an unequivocal intention to benefit the land and not just a person. So it must actually mention the land. The covenant can be made with heirs and assigns of the covenantee, but that wouldn't be enough to annex the benefit of the covenant to the dominant land if it doesn't actually mention the land. Reynolds and Cowlishaw, 1879, is a case about that. So if the covenanting parties haven't expressly shown an intention to annex the benefit of the covenant to the dominant tenement, it might be possible to draw an inference, the intent of the parties, if the instrument, from the instrument that contains the covenant. But if it can be inferred on those terms, then the covenanting party's intention to benefit the dominant land, that will be enough to annex the covenant to the land. But if there's no express or implied annexation, the covenant can be annexed to the dominant land through Section 78 of the LPA 1925. This is called Federated Homes Limited against Mill Lodge Properties Limited, 1980. That's the key case on that point. If that's the situation, the Court of Appeal underscored that Section 78 is only applicable to covenants that touch and concern the dominant land. The court further explicated that a covenant annexed to the dominant tenement, as per section 78, is annexed to each part of the land and not just the whole. So if the estate is split up or sold in small parcels, that right goes with each part of the estate. Following that, the transferee of part of the dominant land has the acquirement of the benefit of the covenants pertaining to that part of the land. In Crest Nicholson Residential South Limited against McAllister 2004, this decision was upheld. It was following the doctrine set out in Federated Homes, but it found that in order for Section 78 to be applicable, the instrument with the covenant in it must identify the benefited land, so then we can ascertain what it is. The court in Crest Nicholson also said yes to the decision in Roke and Charter 1984. The covenanting parties are allowed to expressly or impliedly rule out the operation of Section 78. In Roke and Charter 1984, there was a covenant not to build more than one dwelling per plot on a piece of land. And there was another clause in the conveyance that said the benefit of the covenant would not pass unless it was expressly assigned. The court found that despite the decision of Federated Homes and Section 78, this could not operate to pass the benefit of the covenant to a buyer because the original parties had expressly said that is not our intention. Our intention is different. So covenants created after 1925 were automatically annexed to the land as per Section 78 of the Law Property Act 1925. Express and sometimes implied annexation, along with assignment, are less important than since Section 78 became statute, and is only pertinent to covenants created prior to 1926, but there's still plenty of those around. So Sainsbury against Enfield Borough Council 1989 is a case in point, and it shows the clear point that there can be no statutory annexation in relation to pre-1926 covenants. So suitable words of annexation are still needed in that situation. We'll look at the scheme of development then. In a scheme of development or a building scheme, it's a very utile modern device for the enforcement of covenants in a strictly defined area. If somebody is selling plots of land involved and all the original purchasers of the plot knew that the covenants were binding on them, so they all intended these to be mutually enforceable. And if there is such a scheme as a local law, so they're restrictive covenants and they can be enforced by and against the owners of the plots within the scheme. So the covenant entered into by the purchase of the plot is enforceable by those who bought the plots already and those who buy them later on, and the unsold plots and successors in title. However, you still need to register it. The conditions of scheme of development were set out in Elliston and Reach in 1908, and these are these conditions. So there was originally a single seller of the land within the scheme. The plots of land were laid out in advance. The mutual restrictions were laid down by the original seller for the mutual benefit of all the buyers of the plots. And the purchaser of every single plot knew of the mutually binding nature of the covenants. So another condition was set out in Reed and Bickerstaff in 1909, and it said that the area of the scheme must be lucidly identified. So these obligations seem to be quite burdensome, but there are only 2 reported cases to enforce schemes of development between 1908 and the 1960s. However, in recent years, there have been many. The courts have been a bit more cavalier about these conditions, as in those saying it has to be a single vendor and pre-sale lotting, and they usually tend to insist that you have a clear definition of the scheme. The original vendor, the original purchase, they all intended that purchasers would be bound mutually, and they would have the right to enforce this, and there has to be clear about what the restrictions are. So there are cases about this, such as Baxter against Four Oaks Properties Limited. So although there's a common vendor decided the boundaries of the scheme, he hadn't said what the size of the plots was going to be. Instead of selling each purchaser as much land as he wanted to buy. So Judge Cross said there was a valid scheme in spite of this unusual aspect to it. I'll look at Ray Dolphin's conveyance, 1970. There was no common vendor. The plots had been laid out in advance and the land had been sold over a period of 20 years, but nevertheless they found that there was an extant building scheme. Or Emile Elias and Company Limited against Pine Groves Limited, 1989. And here it was found that the area of the scheme was fixed before the plot commences. So this shows that there's some doubt about parts of that case, Ray Dolphin's conveyance. In Birdlip and Hunter, 2016, the conveyancing documents, they made it crystal clear that the scheme existed. So it's crucial not to go too far away from Elliston and Reacher because that's the leading case in this area. In Whitgift Homes and Stocks, there was a lot of doubt about how much the estate was supposed to be in the building scheme. The Court of Appeal said that there is no building scheme here because the owners of the houses, which were clearly intended to be in the scheme, because, and this is what the Lord Justice Judge said, the authorities show that a number of characteristics must be established. Among them is certainty. Otherwise, in relation to each plot of land set to fall within the scheme, the question will continue to rise, does it or does it not so fall? More precisely, is it or is it not subject to mutually enforceable benefits and obligations? And if enforceable, by and against the owners of which plots? The essential requirement of certainty makes obvious and practical sense. Thank you.